बिस्मिल्लाहिर्रहमानिर्रहीम। अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूअर्स, उम्मीद करता हूँ आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को ऑन कर लें, दबा दें, ताकि मेरी हर नई आने वाली वीडियो आप को मिल सके। और आज हम अपनी सीरीज़ का आगाज़ करेंगे सेक्शन 168। When any subordinate police officer has made any investigation under this chapter, he shall report the result of such investigation to the officer in charge of police station. जब भी SHO किसी मामला के ऊपर, किसी मैटर के ऊपर, किसी मातहत को इन्वेस्टिगेशन सौंपता है, तो इन्वेस्टिगेशन ऑफिसर IO अपनी सारी रिपोर्ट इन्वेस्टिगेशन कंप्लीट करके उसका रिजल्ट SHO के पास जमा करवा देता है। यानी when any subordinate police officer has made any investigation under this chapter, he shall report the result of such investigation to the officer in charge of the police station. Section 169. Release of accused when evidence deficient. If upon an investigation under this chapter it appears to the officer in charge of the police station or to the police officer making the investigation that there is not sufficient evidence or reasonable grounds or suspicion to justify the forwarding of the accused to a magistrate, such person is in custody, release him on his executing a bond with or without sureties. As such, officer may direct to appear if and when so required before a magistrate empowered to take cognizance of the offence on a police report and to try the accused or send him for trial. Section 170. Case to be sent to magistrate when evidence is sufficient. If upon an investigation under this chapter it appears to the officers in charge of the police station that there is sufficient evidence or reasonable ground as aforesaid, such officer shall forward the accused under custody to a magistrate empowered to take cognizance of the offence upon a police report and to try the accused or send him for trial, or if the offence is bailable and the accused is able to give security, shall take security from him for his appearance before such magistrate on a day fixed, and for his attendance before day to day before such magistrate until otherwise directed. When the officer in charge of the police station forwarded an accused person to a magistrate or takes security for his appearance before such magistrate under this section, he shall send to such magistrate any weapon or other article which it may be necessary to produce before him, and shall require the complainant, if any, and so many of the persons who appear to such officer to be acquainted with the circumstances of the case, as he may think necessary, to execute a bond to appear before the magistrate as thereby directed, and prosecute or give evidence as the case may be in the matter of the charge against the accused. If the district magistrate or subdivisional magistrate is mentioned in the bond, court shall be held to include any court to which such magistrate may refer the cases for inquiry for or trial, provided reasonable notice of such reference is given to such complainant or persons. The officer is whose presence the bond is executed shall delivered a copy thereof to one of the persons who executed it and shall then send to the magistrate the original with his report. Section 171. Complainants and witnesses not to be required to accompany police officer. No complainant or witnesses on his way to the court of the magistrate shall be required to accompany a police officer. Complainant and witnesses not to be subject to restraint or shall be subjected to unnecessary restraint or inconvenience are required to give any security for his appearance other than his own bond. Recusant complainant or witnesses may be forwarded in custody, provided that if any complainant or witnesses refuses to attend or to execute bond as directed in section 170, the officer in charge of the police station may forward him in a custody to the magistrate, who may detain him in custody until he executes such bonds or until the hearing the case is completed. Section 172. Diary of proceedings in investigation. Every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation in a diary, setting forth the time at which the information reached him, the time at which he began and closed his investigation, the place or places visited by him, and a statement of the circumstances ascertained through his investigation. Any criminal court may send for the police diaries of a case under inquiry or trial in such court, and may use such diaries not as evidence in the case, but to add it in such inquiry or trial. Neither the accused nor his agents shall be entitled to call for such diaries, nor shall be or they be entitled to see them merely because they are referred to by the court, but if they are used by the police officer who made them to refresh his memory, if the court uses them for the purpose of conducting such police officer, the provisions of the Evidence Act 1872, Section 161 or Section 145, as the case may be, shall apply. Rule of police diaries. Information obtained under this section cannot be treated as statement under Section 161 of the Code PLR 1962, DACA DACCA 1665, Policy Diary Inadmissible in Evidence 1976 SCMR 506, Contravention of section may diminish evidence value PLD 1947 PCA 13 bar applies to special dairy not to general dairy 1990 PCRLJ 1677. آج کے لیے بس اتنا ہی. کل انشاءاللہ سیکشن 173 کے ساتھ آپ کے سامنے حاضر ہوں گا. کل تک کے لیے مجھے اجازت دیں. اجازت لینے سے پہلے میں آپ سے ریکویسٹ کروں گا کہ میرے اس چینل کو سبسکرائب کر لیں, گھنٹی اور لائک کے بٹن کو آن کر لیں, اور تمام دوستوں کو گزارش ہے جو نئے دوست آنے والے ہیں وہ میرے چینل کو سبسکرائب کر لیں تاکہ میری ہر نئی آنے والی ویڈیو آپ تک پہنچ سکے, اور دوستوں کے ساتھ بھی میرے اس چینل کو شیئر کر دیں تاکہ وہ بھی میرے اس چینل کو سبسکرائب کر لیں اور گھنٹی اور لائک کے بٹن کو آن کر لیں. اللہ حافظ.